Good afternoon. Welcome to the RHA's webinar relating to the truck cartel. Thank you very much for joining this session. This session will be recorded, so we'll be able to send it around later on during the week. What we're going to do over the next 20 minutes is run through a series of slides which will explain the RHA's claim against the cartel in detail. Joining me this afternoon is David Went, and David will introduce himself in a moment. Could I also ask that you raise questions as we go along, and at the end we will recap on all the questions and make sure that every question has been answered. The purpose of today is to give you as much information around our action and why we're bringing this claim. So if I could start off by introducing myself. My name is Richard Smith. I'm a director of the RHA. I joined the RHA 4 months ago in order to coordinate the RHA's claim against the truck cartel. Pass over to David.
Hello, I'm David Went. I'm a barrister at Exchange Chambers and I specialise in competition law matters, so I'm part of the legal team working for the RHA on this matter.
So if we move to the first slide, introduction to what the cartel is. And I think it's always important in these situations to understand the detail of what the claim originates around and what actions resulted in the claim. So in 2016, the decision was made by the EC that the European truck manufacturers had operated a cartel for a 14-year period, from January 1997 to January 2011. There was 3 key things that the truck manufacturers did that affected the market. The first one, they aligned gross list prices across Europe on the production line. The second one is the agreed cost to be charged to customers around the Euro 3, 4, 5 and 6 technology. And the third one was they influenced the timing of release of that technology. All those 3 actions had direct impact upon the competitiveness of the marketplace. The European Commission found the manufacturers guilty and imposed the largest ever fine, totaling 2.9 billion euros. In addition, and a point worthy of note on this slide, above the manufacturers that have been listed, is that Scania will form part of our action because currently they are going through the process of being fined. So Scania will form part of our action. So what is the RHA doing? The RHA board decided to bring a group claim for compensation against the truck manufacturers, and the type of claim and the process we will be following will be explained by David in some detail at the latter part of this presentation. The claim will be made for members of the RHA and non-members, so it's an industry-wide claim, and the claim is for people who purchased trucks during the cartel period, and also we believe there is to be a small run-off period, so it could be beyond 2011. Initially, the RHA will apply to the Competition's Appeals Tribunal, which David will speak about in a little bit of detail in a few moments, for a collective proceedings order. This will allow the RHA to act on behalf of the representatives within the class. We expect this process to take 9 to 12 months to get that accreditation. We are also engaging with specialist economic experts so they can define in detail the actual impact of the actions of the truck manufacturers on the price of the trucks and technology that you could have purchased during that period of time. I am heading up the RHA's internal team, ensuring the coordination between the legal experts, such as David, the RHA and our litigation funders. If the truck manufacturers are unwilling to engage in settlement discussions, overall process could take around 3 years is our current belief. So why should the RHA take this action? And there's some interesting key points on this slide. The RHA is a not-for-profit association, so there's not a commercial advantage to the RHA taking this action. The truck cartel is probably one of the largest issues that is facing the haulage sector, and was a major example of competition, of illegal action in the competition arena. The real benefits for people joining this type of claim headed up by the RHA is obviously we are respected as a trade association within the country, if not the trade association that reflects road haulage. Claimants will stand behind the RHA in terms of we will coordinate all the activity, act as a point of communication, the go-to point, and liaise with the legal and technical experts to ensure we have the strongest case possible to achieve the maximum damages awarded. We are also very much aware that operators will continue to need to have a business dealing with the truck manufacturers. The RHA also as a commercial relationship with the truck manufacturers. We represent the industry, we act on behalf of the industry, we also support the truck manufacturers in their products. So we're very mindful of that relationship. The RHA has secured third-party litigation funding on very competitive terms, and there is no cost to operators signing up. Again, David will touch upon that in some detail as we go through the pack. The RHA has over 7,000 members, covering 90,000 trucks. So initially we are very well placed in order to, one, understand what the market's doing, two, the impact upon the members, and three, what the members' wishes are, and also the industry's wishes are around the number of issues. So at this point, I'll pass over to David, who will start to explain exactly what the legal process will be.
Yeah, thank you, Richard. So I'll provide a bit more detail just in terms of the legal process. I'm not going to provide, go into a great deal of detail, but just provide some more information around this. So as Richard said already, what the RHA is doing is bringing so-called collective proceedings before the Competition Appeal Tribunal. Collective proceedings are a somewhat new form of procedure before the Competition Appeal Tribunal, or the CAT, that enable a class representative such as the RHA to bring legal claim proceedings on behalf of businesses that have been affected by cartel activities in this instance. And once the RHA has been appointed class representative, then the RHA is then responsible for running all aspects of the case before the CAT, including those aspects that individual claimants would normally be responsible for. This is getting a little bit technical now, but just very briefly in terms of why these claims can be brought before the CAT on this basis. Obviously, there are efficiency reasons from the CAT's perspective. It prefers a single action by a class representative as compared with thousands of individual actions. But we do need to show that there are common issues across all the companies that are signing up to the RHA's claim. There are then four main stages to the collective proceedings process. As Richard said already, the first stage is that the RHA will apply to the CAT for a collective proceedings order, a CPO. So that does two things. It authorises the RHA to be class representative, and then also the CAT will certify the class. So in essence, that means that there's a definition of companies that can join the RHA claim, and that will be broad. It will be all operators that have purchased or leased trucks since 1997. So the class will be certified, and then it will be clear as to who can opt in to the RHA's proceedings. You then get on to the trial. I've mentioned already that there'll be common issues applying across all those operators that sign up, and so the CAT will look at those issues and determine those issues. There might be some individual issues arising in relation to particular operators, again, that those can be dealt with before the CAT, and then assuming the case is successful, there'd then be a distribution of the compensation at the end of the claim to operators. Now, settlement is possible at any time during the process. I think the message we're getting back from the truck manufacturers at the moment is the suggestion that the 14-year truck cartel didn't have an impact on operators. But obviously, we don't think that's correct, and we're finding evidence to suggest it certainly isn't correct. If the truck manufacturers change their stance on this over time, of course, there'll be an opportunity for the RHA to enter into settlement negotiations on behalf of operators that have signed up to the RHA's action. So just thinking about what operators can claim for, so this slide sets out in some detail what you're able to claim for. So we're certainly looking at trucks that have been purchased outright, trucks that have been purchased on finance, and also leased trucks. We're also including in the claim, in all likelihood, second-hand trucks as well. The intuition there is to the extent that the cartel led to new trucks, the price of new trucks being inflated, then that's likely to have an impact on the prices of second-hand trucks as well. The cartel related to trucks of 6 tonnes and greater, so we're focused on that. It is just possible that the cartel might have had a knock-on effect of prices of trucks below 6 tonnes, and that's something that we're examining further on our side, and obviously we'll update you in due course. We're looking at all brands of trucks, so including DAF, Daimler, Mercedes, of course, Iveco, MAN, Renault, Scania and Volvo, but also other truck brands as well, whose prices might have been affected by the cartel. The relevant period of the cartel was January 1997 to January 2011, but as Richard has already said, there's likely to have been some run-off period before truck prices returned to competitive levels after January 2011 that we'll be able to include in the claim as well. We're looking at trucks purchased or leased in any part of the UK, and may also be including trucks purchased or leased outside the UK as well in other parts of Europe. We've talked about the gross list prices. There's also the emissions technologies piece of the cartel, and it's possible the cartel might have had an impact on fuel costs through the cartel members delaying the introduction of what were more fuel efficient technologies going through Euro 3, 4, 5 and 6. Again, that's something we're examining in some more detail. And generally, you know, the economists that we have working with us will be examining whether operators' costs might have been affected in other ways by the cartel. And again, we'll keep you updated on that. And then a supporting note at the bottom of this slide, you know, we realised the cartel, you know, started operating a long time ago, January 1997. We recognise that you won't have complete records necessarily going back to January 1997, but I think the key message here is you don't need to worry about that at this stage. There are various ways to get the information that we need. In terms of the level of compensation per truck, the starting point is that we're looking at the difference in the price that you will have paid for your trucks during the cartel period and any run-off period. So the difference between that price and the price you would have paid if the cartel hadn't operated. So that's the basic legal test. The RHA has done a great deal of due diligence in this area already, and certainly, as I've already said, you know, we feel that the cartel will have had a material impact on prices that were paid for trucks. And the research that the RHA has done to date suggests that the amount per new truck could well exceed £6,000 on average, depending on the size of the truck. It may be more for the larger vehicle types, Arctics, etc., and lower amounts for smaller weight categories. But that's to give you at least some sense as to what the RHA sees this looking like at this stage. We know that something like 650,000 new trucks were registered in the UK during the cartel period, and so that gives us some sense as to the potential overall level of damages that we're looking at. I think we're aware that you know, it's obviously not just the RHA trying to assist operators in relation to the truck cartel. I think there have been suggestions, certainly by other groups that are looking at this, that the level of damages could be higher, but I think you probably need to treat those sort of figures with a degree of caution. So in terms of how much compensation operators will actually receive if you sign up to the RHA's claim, the RHA has managed to negotiate a very competitive deal with the litigation funder. In terms of the amount of return coming back to operators, in terms of the compensation they're owed, it depends on a number of factors. The key ones are the number of trucks that are included in the RHA's claim, and also the amount of compensation per truck. But I think, you know, at this stage, certainly the RHA thinks it's very credible, realistic that they will sign up at least 250,000 trucks to their claim, and they're well on the way already to that figure. If we assume compensation at £6,000 per truck, that would mean that operators will receive a 91% of the compensation that's owed to them. So assuming £6,000 per truck is owed, operators would receive £5,460 per truck. If the case settles early, then those figures go up, and operators would receive approximately 94% of the compensation owed. Again, if we sign up more trucks than this, or the compensation levels are higher, then the amount of return could be as high as 95%. Clearly, I guess the flip side is if the figures are lower than what we're looking at here, then the percentage return could be lower, and the figure in terms of the funding arrangement starts at 70%. But I think we think it's very realistic that we're going to be certainly at least above 85% based on the numbers already signed up and the level of compensation that we're looking at. So just touching on whether there are any risks for operators in joining the RHA's group claim, and I think the key message here is that there aren't any risks. In litigation, the standard rule is that the loser pays. So if the case proves to be unsuccessful, and we're not anticipating that, given that we've got liability proved by the European Commission already, it's the RHA bringing this case on behalf of operators. So the RHA in bringing the case, if the case were to be lost, it's the RHA that would be liable for the defendant's costs in the normal course. There are limited circumstances in which individual operators, so parties signing up to the RHA's claim, could be liable for defendant's costs, just in relation to any individual issues that apply just to that operator and not to any other operator. So if individual issues come up, then there's at least the potential to have a liability. But what the RHA has done is it's taken out a very significant insurance policy, multi-million pounds. It's the we understand that the highest policy that's ever been taken out in the UK, so it is very significant, and that protects not just the RHA, but it also protects individual operators as well. So if you sign up to the claim, your name is added to that insurance policy. There are typical exclusions. For example, you have to furnish full information, you have to furnish information that's correct and true, but provided you're complying with those basic rules, then you can be protected by this insurance policy. And I think this, just to summarise, I guess, in terms of the benefits of joining the RHA group claim. So we've heard already from Richard, obviously the RHA is a well-respected trade body within the road haulage sector. We know that truck manufacturers at the moment appear to be waiting to see the potential scope of claims across Europe before wanting to engage in any settlement discussions. And their current position is to say that actually, the 14-year cartel didn't have any impact on prices that operators paid. I think as soon as the truck manufacturers are willing to engage in settlement discussions, certainly the RHA will be first in line to lead the way with those discussions, including through having very close contacts with the truck manufacturers here in the UK, and will be able to bring significant negotiating clout to those negotiations. The RHA is obviously taking its obligations to the haulage sector very seriously in deciding to bring the claim. As Richard said, obviously the RHA is aware that truck operators will continue to have business dealings with the truck manufacturers after the claim, so that's an important dynamic. There are clearly economies of scale in the RHA doing this, and you can see from the levels of return to operators, which may be as high as 95%, you can see the benefits of joining a large action. And that ties in with the extremely competitive litigation funding package that's in place. We've talked about the significant insurance after the event insurance that's in place as well. So that means that individual claimants are protected against the risk of costs if the case is lost. And we understand actually the RHA has probably tied up a lot of the capacity in that insurance market. It's a very niche insurance market with limited capacity. We don't think there's much capacity left in the market given the policy or the amount of insurance that the RHA has taken out. The RHA is obviously seeking to achieve the optimal level of compensation for operators. We will obviously be banding operators in different classes depending on the common issues that apply within classes. And I think certainly, whether you're a larger operator or smaller operator, certainly your voice will be heard within the claim. And as Richard has said finally, so the RHA doesn't intend to profit from acting as representative, which means, of course, that maximises the level of compensation that will be returned to those who've been affected by the cartel. So I think we've got a few questions that have come in. So maybe we can go through those. And obviously, if others have further questions as we go through this, but please feel free just to type those. We can take questions as we go along. But let's go through the questions that we've had so far, and Richard and I will both chip in on these, I think. So what date range for trucks purchased are applicable under the claim? So that's the first question. And so I guess, as we said already, I mean, the truck cartel started in January 1997, so that's the starting point for the claim. The cartel ended in January 2011 when the European Commission conducted dawn raids. But we know that just prior to that, the truck manufacturers were exchanging future price lists, at least for the following year. They were also discussing the Euro 6 technologies. So I think on that basis, it's unlikely that prices would return to competitive levels immediately in January 2011, but there will be a run-off period after that that we can continue to claim for. And that's something that the expert economists legal team are examining still in some more detail. So that was the first question. We've then had a few questions around the level of evidence that's needed to, that operators need to provide in terms of evidencing the claim. So bearing in mind the years which have passed since buying new trucks and then disposing of those trucks, what proof of vehicle ownership is required? I think generally speaking, it's worth saying the RHA will certainly be trying to minimise the amount of information that we need to gather from operators, and I think there are various ways of getting the information that we need. Clearly there's third-party information sources. There's DVLA, there's operating licensing data that we will try and draw on. There will be the potential also to make requests from third parties during the legal process. So, for example, either from dealers or from the truck manufacturers, of course, themselves. I think we're aware that asset registers are a very good source of information within the companies, within the operators signing up to the action, and that will obviously give information also on, or likely to give information on, the price at which the trucks were purchased. So I think there are various ways of getting the information that we need, and we will, to some extent, obviously be relying on operators. But I think, as I said already, the key message is, to the extent you don't have records going right back to 1997, don't worry about that at this stage. There'll be other ways to get the information that we need, I think.
I think just to add to that, David, another question we've been asked is, if we acquired a company during the cartel period, can we include those vehicles? And the answer is yes. Those vehicles will be included in the claim. Yeah,
absolutely. So, I mean, in principle, that's absolutely right. I mean, it depends a little bit on precisely how the companies might have been acquired during the cartel period, and depends on how the rights and liabilities of those businesses passed to the acquiring company. But I think the starting point definitely is that we should be able to claim for those trucks as well. I've also had a question just in terms of trying to clarify the situation in relation to Scania's involvement in this matter. So as Richard was saying a bit earlier in the presentation, we're planning to include Scania in the claim from the outset, notwithstanding that the investigation continues against them by the European Commission. We'll obviously need to see, where that investigation goes, but it may well be that at some point in future, Scania is equally fined for cartel activities. But we're planning to include them from the outset. That there's a legal basis on which we feel we can do that. So right from the outset, if you've purchased all these Scania trucks, those can be included in the claim.
Yeah. Another question we've been asked is, the fines that have already been levied, 2.9 billion euros, where have they gone?
Yeah, and they've gone into the European coffers, in essence. So it goes into the European budget and then reduces the amount that member states have to pay into that budget. So the UK will have had somewhat of a reduction in what they need to pay as a result of the €3 billion fine. But unfortunately, that's not money that we can seek to claim in terms of the compensation claims that are being brought here. We've also had a question, the extent to which there's been any contact between the RHA's appointed legal representatives and the manufacturers. I mean, as we said already, the RHA, of course, has close relationships with the truck manufacturers, who are also members of the RHA. And certainly the RHA has gone about bringing this action in a transparent way in relation to the manufacturers, and has been keeping them up to date with the plans for the action. So there has been some dialogue, and that will continue as this claim progresses as well.
Okay, another question again that we've been asked, and this is just to reinforce some of the points in the presentation. What is the fee to register? There is no fee. There is no sign-up fee to join the RHA claim. There is no fee other than at the end, obviously, when an element goes back to litigation funder, which David's clearly explained what's that based and related to. Another question is, we are a UK-based PLC and have multiple operations in Europe. Can we include these in the RHA claim?
Yeah, so the way that the claim has been structured and the way that the funding has been set up, certainly that there's an entitlement for the RHA to be able to bring claims not just covering UK purchases, leasing, but also claims outside the UK as well. There are potentially some jurisdictions around this in relation to the collective proceedings before the CAT. But certainly the plan is to, for the RHA to extend its claims to include purchases outside the UK as well.
Again, another question. I think this is the same question, but it's been asked in a different way, so we'll just clarify this. When will we know if vehicles bought in Europe can be included in this claim?
Yeah, so I think that goes back to the same point. So it's certainly what the RHA is doing, and its intentions here is to be bringing claims, across Europe if there are members, non-members in the UK that have made purchases leasing outside the UK, and we're giving more thought still to precisely the method in which that will happen. So whether it's part of the collective proceedings or separately, but certainly the RHA's intention is to cover such purchases as well.
Okay. And another question we've been asked is, has any contact been made between the RHA appointed legal representatives and any party representing the manufacturers? The answer is not between the legal representatives at this stage, but Richard Bennett, the RHA CEO, has been in contact with all the truck manufacturers and has met with the truck manufacturers to explain our action, the purpose of our action, and how we intend to proceed. And now we are in constant, continual dialogue with the MDs of the relevant businesses. So we are actually speaking to the truck manufacturers from an RHA perspective at this moment in time, and intend to continue to do so.
And we've had some more questions coming in, just looking at, if you like, corporate succession acquisitions during the cartel period. And I think, some of these points will turn on the particular facts. I mean, but as a starting point, certainly, if you've acquired companies that will have purchased trucks, if you've acquired companies during the cartel period, during any runoff period, you will be able to claim for those trucks that were purchased prior to the acquisition. That's certainly the starting point. But I think at the end of the day, we will, from a legal perspective, need just to examine the particular facts of the particular case, just to give you proper advice in each case. But that's certainly the starting point. If you acquired a business during the cartel that had purchased trucks, you can also bring a claim for those trucks as well.
Another question we've just been asked, David, on this one we are debating or finished debating. Will lease companies be able to make a claim? We're still debating that.
Yeah, this is something this is something that we're still looking at in more detail.
So the guidance at this point is please register if you're a lease company, and we'll consider that during the process, as we believe there may be a claim there may not be. But as David said, from a legal perspective, we're still considering that.
We've had a question also come in. So when does the claim start from? When is the deadline? And also, I guess, linked with that, when does the group action formally commence? In terms of the group action and when the RHA plans to issue proceedings, that will be sometime later this year. We're obviously encouraging operators to sign up as soon as possible. That's certainly helpful from the RHA's perspective in bringing the group claim and applying to the Competition Appeal Tribunal. So I think, so certainly, the message to operators is to sign up as soon as possible now. Once the collective proceedings order has been granted by the Competition Appeal Tribunal, there will then be a window, perhaps of 3 to 6 months, during which operators will formally be able to opt into the RHA's claim. And once that window has ended, after the CPO has been granted, that will be the cut-off point, or likely to be the cut-off point, beyond which you can't then join the claim.
Okay. Another question we've just been asked, David, which I think you've picked up in the presentation. How will the cartel have affected out-of-Europe manufacturers such as Hyundai? Will there be any compensation for these vehicles? So these would be manufactured outside Europe, but would be purchased within Europe or leased?
Yeah, sure. So I think as we had a slide a bit earlier, just explaining, what could be claimed for. In that slide, obviously, we listed all the main brands of the truck manufacturers involved in the cartel, and obviously including Scania, who continue to be investigated by the European Commission. Clearly, a very large percentage of trucks purchased in the UK and Europe will relate to those major European brands, but we're aware that there are other truck brands being sold in the UK, in Europe, that would have been sold during the cartel period. So brands such as Hino, Isuzu, there'll be others as well. Typically, when a cartel covers such a large part of an industry, but there may be some manufacturers that sit outside the cartel, typically what happens is that the prices of trucks, in this case, the products sitting outside the cartel, will have been affected by the prices of the cartel. And we can also claim, so to the extent that the prices of Hino trucks, of Isuzu trucks, of other brands of trucks have been affected by the cartel, then we can claim for that against the members of the cartel. And certainly we plan to include other brands in the claim that RHA is bringing, subject to the economists, when they examine this, confirming that there was an impact on those truck brands sitting outside the cartel. Okay.
One question we've been asked is about limited companies that have wound up during the period or ceased to trade. And the answer is you can register and sign up to the claim if you're a business that went out of business during that period but purchased trucks. That is included.
Yeah, I think in terms of companies that have been wound up, the claim could potentially have ceased to exist at the time the company is wound up. I think insolvency practitioners may have ways to resurrect companies with a view to bringing claims, but of course that's becoming a bit more specialist, and I think again that's the type of situation we'd need to look at in more detail.
Another question we've just received, David. We are registered as a UK-based arm of a multinational PLC. Will we need to register as the group PLC to include the European-based operations?
Yeah, I think at this stage, it's obviously important to sign up to register, or to register and to sign up to the RHA's claim. We'll obviously need to be examining, as to whether we've, definitely got the right corporate entities signed up. And that's a process that will happen over the next few months once you have signed up, just to determine whether we've got the right entity signed up. So that's something we can again explore with each individual operator in due course.
And again, we have another question around will dealers fully cooperate in providing proof of purchase? Again, it's a proof of purchase question. For vehicles over the period between 1997 and 2011, or will the onus be on us? And I think you've answered that question, that obviously as we get more and more into the legal proceedings, there will become our ability to get access to information through the disclosure process and through other legal means to actually can confirm what we believe to be the case. So,
yeah, that's right, exactly. That's right, Richard. I think there are various ways of getting the information we need, and one of them may be seeking information from dealerships, certainly.
Okay.
There's one more question that's come in. So is there a defence that the manufacturers could use as, so looking at the overcharge that's been charged to operators, given that may have been a cost that would have been factored into haulage rates charged to operators' customers, the question is actually, is there no detriment here? Is that an argument that truck manufacturers can run? And certainly what what the courts here try to do is compensate operators for the losses that they've suffered. I mean, that's the starting point. And so I think it's certainly true that truck manufacturers may try to claim that operators have merely passed on any overcharge to their customers. That's an argument that they're likely to run, and this is an argument that's typically run in these types of cases. But I think actually we've got some good arguments to defeat that position by the truck manufacturers. I mean, it's true in a broad sense that, of course, operators over time will want to be passing on all their costs in the prices that they charge the customers. If you don't pass on your costs, you'll go out of business. But actually the legal test around this is set at a very high level, which means I think the truck manufacturers are going to struggle to say that that there has actually been pass on of the overcharge to customers. So the bar is set very high. And in essence, what the truck manufacturers would need to show is that there's a direct causal nexus between the overcharge, so the amount too much that operators paid for the trucks during the cartel period. There's a direct causal nexus between that overcharge and prices charged to individual customers. And if they can't show that, and it's very hard for the manufacturers to prove that, then I don't think the manufacturers will be successful in that argument.
Okay. Well, I think that ties into another question that we're being asked, and correct me if I'm wrong on this, David, which is quite a long question. As per one of your slides, it said finance, lease and operating lease trucks. But how does the operating lease ones work into this as rates set by the leasing companies, not the manufacturers really? And what proof would you need? And what's the start and end date? So does that sound the same?
So I think, our understanding is that certainly with leased trucks, the amount that is paid under those leases is related certainly to the cost of the truck. So the cost of the truck that the leasing company has paid. So on that basis, there does seem to be a directly link between a potential overcharge and the leasing cost to operators who lease trucks. It's on that basis we feel that there should be a claim by operators that have leased trucks as opposed to purchased them. And that claim would still sit obviously against the truck manufacturers, because it's the increase in the lease price that the cartel has caused.
Okay, you got any more questions, David?
No, I think we're coming to an end actually with the questions that I can see.
Okay, and just finally before we close, we have a website which is specifically designed for the truck cartel, and on the website we have 75 question and answers, which again over the course of the last 6-7 weeks, as we've been developing the legal action, we've purposely put them on the website. So please feel free to go to that website and look at the Q&As, and the contact details for the key people involved with the action are displayed on the screen as well. So please contact us. And finally, we will be at the Autumn Conference, the RHA Autumn Conference, discussing with delegates who join the conference this matter in particular. So please feel you can come along and speak to us there as well. And I think we have no more questions. David, any final comment?
No, thank you.
And that's fine. Thank you very much for joining the webinar, and please speak to us if you have any further questions. Thank you. Good afternoon.